Hello everyone, I'm Ankit and you're watching StudyIQ IAS English. In our today's video, we'll try to talk about Article 137 of the Indian Constitution. To summarize it to you right now, Article 137 gives the power to Supreme Court to review and recall its previous judgments. But why are we talking about Article 137 today? We'll soon find out. The notes that I will be using in our today's session, in case if you want to download them, you can go to this particular Telegram channel, ETS Live. And while you're at it downloading the notes, please do not forget to subscribe to it also. So let us start our today's discussion by understanding why are we talking about Article 137. But before that, you need to understand something. Before starting any project or construction project in India, you need what is called as environmental clearance. But there were many projects in India, public and private, that were started without the necessary environmental clearance. And this matter is the central government. So to give certain of these projects retrospective clearances, that are backdated clearances, also called as ex post facto clearances, the government came up with two notifications, that is 2017 EIA notification and 2021 Office Memorandum. And these two regulations by the Union government give certain economic projects the retrospective environmental clearances. Now this matter reached the Supreme Court, and in the month of May, Supreme Court came up with a judgment popularly called as Vanashakti judgment. And in this judgment, the Supreme Court struck down both of these governments' notification. So this review petition of this Vanashakti judgment was again filed with the Supreme Court. And in the judgment which came last week, the Supreme Court recalled its Vanashakti judgment using its power which is given to it under Article 137 of the Indian Constitution. So this is the reason why we need to understand what is Article 137 all about. Okay. Now you need to understand these kind of questions have been frequently asked in the exam. Case in point, this 2021 question, just read the second statement. The High Court in India has the power to review its own judgment as the Supreme Court does. So do you think you'll be able to solve this question without having the discussions pertaining to Article 137? No, right? So that is why we are discussing these questions, because these type of discussions are important from your exam's perspective. Right? Now, first, let us understand how are environmental clearances given in India. Now, as I told you, before starting any economic project, you need environmental clearances. And this is a statutory requirement, which is a law, right? And this law is laid down under Environmental Impact Assessment Notification of the year 2006. But who gives this environmental clearances, that we also need to understand. And there is a three-level framework for it. For major projects that relates to Indian economy, the environmental clearances are given by Ministry of Environment, Forest and Climate Change. For mid-level clearances, these environmental clearances are given by state authorities, be it central, state pollution control board, state environmental ministries, etc., etc. Whereas for smaller mining activity, these clearances are given at the district level, mostly by district administration. But before getting these clearances, every project needs to follow a certain process, and this process includes screening, scoping, appraisal, and if need be, also conducting of public hearing to discuss the environmental effects of these processes. And all of these are combinedly called as Environmental Impact Assessment, or EIA. So this is the process which any economic project has to follow before it gets the necessary environmental clearances. And this environmental clearances needs to be given prior to the starting of construction of those projects. Okay. But despite this statutory requirement of environmental clearances, there have been many projects in India who have started these projects or construction of these projects at the time when their application is still under process, when their application has not gotten the required environmental clearances approval. And this cases is not just related to private projects. Even several important government projects have started without the necessary environmental clearances, be it AIIMS campus in Odisha, be it greenfield airports in Karnataka. So when these kind of projects created a backlog, this matter reached the union government. And that is why union government issued two notifications, the 2017 and 2021 notification, which provided a one-time violation window for these projects to get a retrospective approval. That is, by paying certain kind of monetary fines, these projects were given a backdated approval so that these projects are executed, but the monetary fine acted as a deterrent so that these kind of violations are not replicated in the future, right? But this matter, when it reached the Supreme Court, a bench of two judges, that is Justice Oka and Justice Bhuyan, they struck down these two notifications under what was called as Vanashakti judgment. And their argument at that time was that retrospective clearances contradicts the original aim and approval process that was meant under environmental impact assessment. So it required appraisal and public participation before work happened or work began, and this retrospective process of clearances violated this very soul of the process, that was environmental impact assessment. So that is why under Vanashakti judgment, this two notification was struck down by a two-bench judge bench of Supreme Court. Now this matter reached to the Supreme Court again by filing of review petition. And this review petition, which was filed to Supreme Court, was filed under Article 137 of the Indian Constitution. So let us now understand what Article 137 of the Indian Constitution is all about. I'm sorry. Now, Article 137 of the Indian Constitution, it empowers the Supreme Court of India to review its own judgment through review petitions which are filed to it. Now, usually such petitions are heard by the same bench who has given the original judgment. But in certain cases, when the existing judges have retired from office or they are not available, these are given to a separate bench, right, who have not delivered the original verdict. But you need to understand this power, although it is there with Supreme Court of India, but it is rarely exercised because of certain reasons. First of all, before any judgment which is passed by the Supreme Court of India, that case has already gotten through multiple layers of hearings, which starts at a trial court, goes to an appellate court, and ultimately it is given by the Supreme Court. So when a case goes through multiple layers of judicial hearing, it is expected that any matter which could have been reflected at the time of hearing must have been already addressed by either one or multiple layers of Supreme Court, because the judiciary or the judgment which comes from Supreme Court has usually survived multiple rounds of judicial scrutiny. And if you were to add another round of review, it would already create a backpile of multiple cases, which we all know in case of Indian judiciary is too huge. So that is why justices, especially in Supreme Court, are reluctant to let this litigation become a process of endless, and that is why this kind of a power is rarely exercised. But in what cases are these powers exercised, we need to understand. Now, usually the review, if it were to be done by the Supreme Court, it is done under very narrow grounds. What are those narrow grounds? First ground is that when there is error on record of when the Supreme Court identifies that their judgment was erroneous. So this is the first ground. Second ground, if that any evidence comes to light which was not there in the initial stages of hearing, then this is the second instance where the Supreme Court reviews its own judgment. That is first in cases of error in judgment, second in cases of emergence of new evidence that has come to light. So that is why this review is done only on narrow grounds. It is not a wide ground because it would already add to the backpile of cases that is already there with multiple levels of judiciary. Now, what was the reasoning given by Supreme Court when it invalidated the Vanashakti judgment? Now, first reason that the Supreme Court provided, that in the first instance, during Vanashakti judgment, Supreme Court failed to consider the binding precedents of its previous judgments. If you remember, the Supreme Court stated that this judgment was delivered per incurium, which means it overlooked earlier coordinate bench decisions. For example, Common Clause 2018 case, where Supreme Court, although it criticized the concept of retrospective clearances, but it still allowed it because certain existing projects were needed to be regularized. But to deter from certain instances from happening in the future, Supreme Court imposed severe monetary penalties on it. Similarly, if you look at D. Swamy versus Karnataka State Pollution Board control cases, in this case also, Supreme Court permitted post facto environmental clearances, but only in exceptional circumstances. So to say that retrospective clearances have never been provided, it would be incorrect, because we have common precedents as recent as in 2021 or in 2028, where Supreme Court, although albeit has allowed for retrospective clearances to go ahead with sub monetary penalties. So this was the first reason. Second reason is the principle of proportionality, because if we were to go through the letter and spirit of the Vanashakti judgment, it would lead to severe economic loss for India, for private as well as for public government. Now, if the government or if the Supreme Court were to go ahead with the Vanashakti ruling, it would require demolition of many important and even completed public infrastructure, most of which has been created or constructed using public money, right? So this would not just bring a severe public harm or financial harm to the government, but it would also lead to negative impact on these project developers. And if you look at 2017 and 2021 notification, the government had already imposed heavy penalties, which would in future act as a deterrent and would prevent certain instances from happening in the future. So the Supreme Court realized that yes, there exists a deterrent, there exists a penalty. So that is why us going forward with Vanashakti judgment would actually violate the principle of proportionality, because it would lead to huge economic loss. So this was the second reason why the Vanashakti judgment was struck down. The third reason was environmental harm that might come from demolition of such projects. Now, you need to understand large-scale demolition activities, it generates huge debris, it creates dust pollution, and it also leads to emissions of particulate matter. So, Supreme Court noted that if you were to rigidly enforce the Vanashakti judgment, this would paradoxically ultimately harm the environment, which was the original intention, not to go ahead with the retrospective clearances. So this was the third reason given by Supreme Court to allow for recall of Vanashakti judgment. And to summarize, the recall or review of judgment happens under Article 137. Is it usually used? The answer is no. It is rarely used. And it also has very narrow grounds on which it can be used. What are narrow grounds? I told you. First is error in judgment. And second is emergence of new evidence which did not come into light during the earlier instances of hearing, right? So this is all you needed to know about Article 137. Now, before we solve the question that I showed you before, you need to get something very clear about you. Now, when you approach your UPSC prelims, you not just deal with the kind of articles or the kind of discussion we had today, but several other important topics which are not even there in the news. So how do you think you would prepare about it? The best way to do that, let me tell you, is to take admissions in our resolution batches. Now, when you take admissions in these batches, now what happens is that everything, each and important subject is addressed structurally by subject matter experts. You are provided with class notes, you have access to mock test, one-to-one mentorship, and everything is available for students under resolution batches. The name itself, P2I, means everything from prelims to mains to interview is covered here. Now, if you take admissions in 2027 or in 2028 batches, one thing that you should keep in mind, that if you use the code ATS Live, it will help you fetch maximum discounts, not on just these courses, but also on optional courses. But to get this discount, you have to apply the code ATS Live. It is very simple to remember it. Learn to thrive by using ATS Live. Okay. Now let us take this question which appeared in 2017 in India. Judicial review implies what? Judicial review basically is the power of judiciary to pronounce upon the constitutionality of laws and executive orders. This is the right question. All the other options are incorrect, right? This power of judiciary to review its own judgment given earlier in another case stems from Article 137. Now the next question, with reference to Indian judiciary, consider the following statement. Any retired judge of Supreme Court of India can be recalled back to sit and act as a judge of Supreme Court by the Chief Justice of India with prior approval of President of India. This statement is right. Second statement, a High Court in India has power to review its own judgment as Supreme Court judge. This is incorrect. You know why? Supreme Court gets this power to review its own judgment, as we have already discussed under Article 137. So this is a constitutionally recognized power, and this is a very wide power. Supreme Court cannot just address the error in judgment from its own on judgment, but it can also review the constitutional requirements. Whereas the power given to High Court is very narrow, which stems from the erstwhile Criminal Procedure Code. Right. So in that regards, High Court does not have a power to review its own judgment as the Supreme Court does, because there is no judicial authority above Supreme Court. If there were to be error in High Court judgment, that can theoretically be rectified by the hearing when it goes on in the Supreme Court. So second statement would be incorrect. So from this discussion, option A is your right answer again, because statement is incorrect, right? And the notes, if you want to download them, you can go to this particular Telegram channel, ATS Live, and if you have troubles finding it, you can scan this QR code and get the same. Okay. So this is all from my side. Please have a very good day, and we'll see each other again today at 9 p.m.